Hello everyone, this is Gaston from Markman Advisors here for this week's Markman Minute. This week I wanted to talk to everybody about a situation that we covered in one of our earlier Markman Minutes, which is the $1 billion appeal in a case involving Carnegie Mellon and Marvell Semiconductor. As we talked about last time, this is a closely watched case for investors in Marvell and more generally for people that are interested in patent litigation. $1 billion verdicts are few and far between, and there's a lot of interest in determining whether or not this verdict will stand. And there was an important event last week in this case, the Federal Circuit argument between Marvell and Carnegie Mellon. I happen to have been there live. It was a definitely interesting scene, a packed courtroom, standing room only, a mix of, I think, the litigants, their lawyers, their large legal teams, a lot of reporters and interested observers that were there to really see how the Federal Circuit was going to treat a case that has a very high number in terms of potential damages. So the courtroom, as I said, was very crowded. Probably more crowded than for a typical Federal Circuit argument, but again, indicative of the importance of this case to both the companies involved and I think the general public that focuses on the value of patent cases. There was a little bit of a comic beginning to the proceedings because the Federal Circuit, in addition to sitting on patent cases, also hears appeals from disability benefits filed by veterans. And while that's not a laughing matter and it can be very serious for the veteran involved, it just shows the scope of what the Federal Circuit has to deal with. On the one hand, they're listening to argument about one veteran's disability benefits, and then 2 minutes later, the same panel of 3 judges is sitting on a $1 billion verdict involving one of the world's leading research universities and a very large semiconductor company. So the argument started, as I said, there were 3 judges, as there typically is in a patent case. This argument was given a little bit of extra attention. It was set for 30 minutes aside. The typical Federal Circuit argument is only 15 minutes aside. So I think the panel was respectful of the importance of the case to the parties involved. But I think also for investors, there may be a little bit of a disconnect between the fact that this is a case that was filed over 5 years ago, spent many years in the district court, and now is coming up for almost a complete review with judges that are going to give it 30 minutes of argument on each side and then take a couple of months to a year to decide the case. The argument itself was very well done. Both sides had leading appellate lawyers handling the argument. The panel, which is the 3 judges, was very engaged, quickly jumping into the issues that they thought was important. And it became very clear early on in the argument that the keynote issue was going to be damages. And this case presented a number of interesting damages issues. Probably the most interesting one to both the panel and to investors and patent practitioners is how is the court going to deal with the extraterritoriality or foreign sales component of the damages verdict. When someone like me is at these arguments, I try to spend as much time as I can looking at the judges, reading their body language, seeing what kind of questions they're asking, and then seeing how they're interplaying the questions off each other. It also becomes very clear when you're in the courtroom when the advocate is giving a little bit of an evasive answer. So reading these tea leaves can be very, very helpful. And I think the consensus that's going to arise from people that were there and others as they listen to the oral argument online and maybe think more about what transpired at the hearing is that there is a chance that this verdict may be sent back down for a remand and a new trial at damages, both to develop the evidentiary record a little bit more with respect to Marvell's sales process, but also to make sure that a jury does as complete a job as possible in terms of evaluating the true value of these patents to Marvell. Now, obviously, it's very hard to prognosticate which way a decision is going to go, but I do think that the focus on damages at yesterday's hearing suggests that the opinion that issues is going to potentially make some very important points, both for Marvell investors, for people interested in universities and how they license their patents, and more generally for people that are interested in patent damages. So all in all, it was an event that lived up to the hype, and we look forward to the decision coming down when the panel gets around to doing so. It may not be the end of the story, but it's going to be a very important step in this long-running saga between these two important litigants. Thank you very much. You can catch our content on mimesiswebtv.com. I'm Gaston, and this was the Markman Minute. Catch you next time.